All right, we should be live now. Hopefully everybody can start to hear me as we have people sign on. I'm going to bounce behind once or twice before we get started. I start seeing some names pop on here. As always, my partner Mario Barnaby is behind the scenes running the show for all of us today. I'm going to check real quick. All right, the viewers are popping on. I truly feel like this is going to be one of our best ones ever. Because as you go through this and as we go through the meeting today, we're going to talk about the unfair claims practice laws in a few states and run through the types of things that these laws actually say so that you can have an understanding as to how to use this against the insurance company doing your claims to not only get better results, but to speed up the claims. So that'll make a big difference, hopefully, for everybody involved. For those who don't know, as you're signing on, my name is Tony Youll. I am the owner and partner at Wheeler, Youll and Barnaby. And right down here in the bottom corner, you've got my contact information. That's my personal cell phone and my email. You can use them anytime with questions. I'm happy to respond, happy to get back to you because of some good changes around here. I've gotten 2 more attorneys on my staff. I'm able to help out more with these questions that come up. I just did a call yesterday with some adjusters who needed some help on a claim. So took a half hour of my day, but I don't mind doing it. So anytime you've got questions about policies, specific claims, anything that you might need, feel free to let me know. We're going to give it a few more minutes while people are starting to sign on. The other thing to know, my office is in Pennsylvania and New Jersey. That's where my practice started, and that's why today you're going to see the 2 examples for the states that we go through are Pennsylvania and New Jersey. Now, I've expanded outside of Pennsylvania and New Jersey now. I've been lucky enough to be called in multiple states across the country to act as a legal counsel for them. So I want to reiterate, if you've got questions outside of those 2 states, please let me know. I'm happy to help, see what I can do to assist you with those. The other thing I'd really like from you guys is some feedback. I don't send out, or I haven't yet sent out any kind of feedback response emails to see how we're doing. But in the chat, or if you want to send me a message personally, let me know what you think of these lunch and learns, or even most importantly, what you want to learn in the future. What topics would you like me to talk about on future lunch and learns, so that I make sure that whatever we bring up are things that can actually help you guys. This industry, as I constantly say, it's really us versus them. There can often be a competitive nature between adjusters in this industry, but the real truth of the matter is if we have a unified front as an industry on this side of the policy, we will have a much better chance pushing back against these insurance companies. The other thing to note, as most of you know, Hurricane Ida has passed through the country, and there's a lot of people that are probably missing this talk right now that otherwise would be joining. I'm going to obviously have this posted on the website for anybody to watch, but if there's enough interest, I'm actually going to give another talk on this topic and expand on any issues that might come up so that we make sure we hit all of this because it's really important stuff. As always, we are here for the live chat as well. So behind the scenes, again, is my partner Mario Barnaby. He is manning the questions. You can ask questions at any time during this chat. So even right now, you can post your idea of, hey, Tony, next time you do a lunch and learn, can you talk about this? You can post it right now. We can see it and save it and respond. Or if you've got questions about the slides that come up, let us know while we're doing it. One of the nice things is before this, I mean, we had hundreds of people that were responding to this lunch and learn, and a number of questions that people can put in. When you register, you can ask a question. And we always go through those questions, candidly, even if they're not related to the topic, because I want to make sure that everyone feels like I am actually here to answer your questions, because that's how I feel. Last but not least, I say this every time, in every talk I give. In an ideal world, you don't need to use me. If I can keep claims in your pocket, keep money in the insured's pockets, and not have to pay an attorney, great. That's why I do these classes. It is to get information out there so you don't have to come to me. But if you've got questions during the claim and you need my help, let me know. I'm happy to answer those questions. And 99% of the time, there's no cost to do that, just to answer a question on the phone. And then if you hit a wall with the his client's insurance company, and they're not paying what they should, or they've denied the claim, I'm happy to help with those too. That's what I'm here for. All right. I think we're getting some people signed on now, and the numbers are going up, which is always good to see. So I'm going to get started. Again, today's class is all about unfair claims practices laws. In almost every state, there are laws that regulate what insurance carriers can and cannot do. And these are generally going to be just minimum standards. This is the bare bones of what need to happen. And in a large majority of the time when I speak with adjusters, they don't actually know what is in these laws. Because when they find out, they say, oh my gosh, that's something that the carrier has to do. I had no idea. The purpose of today's class was to go through what those laws are. So, what you're going to learn today, hopefully. Oh, I skipped a slide. Although I'll do it right now. Our shameless plug for Mapia. Mapia is the Mid-Atlantic Association of Public Insurance Adjusters. I'm a litigation counsel for Mapia, but it is a fantastic organization. The entire goal of the organization is education and lobbying for the rights of public adjusters in our industry. So if you're not a member of Mapia or another organization, you have to ask why. We offer free CE credits. These lunch and learns are great, but you can actually get CE credits if you join Mapia. We offer a holiday party that's coming up this year. We do mid-year parties. They include food, drinks, live Q&A with myself, other attorneys and other experts in the industry, and you get to support a lobbyist. One of the biggest things that we can do to push back against insurance carriers is to have a lobbyist in Congress that helps us out. You've got to recognize insurance companies have endless pockets of money. It's really crazy how much they have, so they can pay to have almost any law put into a bill somewhere. Our lobbyist, who is unbelievably good, has been fantastic for the industry and pushes back to make sure that the ones that are bad for public adjusters don't actually hit the floor for a vote. So it's only $300 a year, $300, and it's tax deductible. It gives back to the industry, and it provides information and resources for you. Again, if you're not part of it, you've got to ask yourself why. All right, so what you'll learn today. We'll talk about what the statutes actually say, how to use the statutes to move a claim forward, and what to do when the carrier doesn't comply with those statutes. Now, before we go into this, I had a lot of internal debate with myself over whether or not I just post the language of the statute and go through what that means, or give you guys kind of the abbreviated version of it for both time's sake and readability. The statutes aren't horribly difficult to read, and they're not actually, in the grand scheme of statutes, terribly long. But for purposes of the lunch and learn, I decided it would just be too much writing and too much information to actually just copy and paste it. So we're going to go through what is actually meant in these statutes. And if you have specific questions about actual language in one or another, let me know. I'll be happy to talk about that. For most of them, I've also given you the code number for where it's coming from, so you can always look it up and look up the number yourself. Just as a very brief background for those who don't know, statutes or codes, regulations, these are all different terms that are used in the industry, but for the most part, all of them are going to be laws. That is the term that generally people are going to understand. It is a law, which means that the carriers have to comply with these things, and if they don't, there are penalties for it. Now, in some of these, there is no form of a private action, which means your client couldn't sue the insurance company just because they violated one of these. But in almost every state, a violation of these codes is very, very strong evidence of bad faith. So you want to make sure that you understand these, because again, to build those bad faith claims that really teach these insurance companies a lesson versus the just standard breach of contract, you're going to want to understand what these codes are. So let's jump in, because there's a few of these. New Jersey is where we're going to start. In New Jersey, we have the Unfair Insurance Practices Act. It's also the similar name that you're going to see for Pennsylvania, and it's all based off of the NAIC. It's the National Association of Insurance Commissioners. And the NAIC put together a model act to say, here's what we think your act should say. They pass it out to the states, and the states can adopt whatever they want. They can either copy it exactly the way it is, or change it based off of their own preferences. Now, in New Jersey, they've got a provision in there that says this act only applies if it does not apply for commercial policies over $10,000 in premiums. I miswrote that. That's a mistake that should be edited. Mark, are you able to edit that real quick? This does not apply to commercial policies over $10,000 in premiums. So, in other words, if you've got a large commercial loss and you take a look at their premium and they notice that that premium is over $10,000, these acts don't apply. Don't ask me why. I've got no reason under the sun why this would not apply to large commercial losses, but such is our life. So the first one to look at, the carrier must provide this code to employees and make sure that they know what it says. That's actually really a big deal, right? Because when you're dealing with the adjusters for the insurance company, they're held accountable for everything we're going to go through under the New Jersey statute. So if they are violating one of these, they can't come back later and say, "Oh, I didn't know about that." The code specifically says the insurance companies have to distribute this entire code to their staff who are enforcing the policies, and the carriers are responsible to make sure they understand it. So that's actually a really big deal. This one probably doesn't surprise anybody, but the letters that they send out to the clients, and by the way, you're a representative of the client, so if they're sending it to you, it's like sending it to the client. They have to be easy to read with understandable terms. So they can't use complex language that the average person would not be able to understand. I also want you to recognize the average person out there might not understand a lot of these letters, and you can always ask for clarification. You could use this code and say, "Hey, look, my insured doesn't really understand what you're saying here. Can you clarify by answering X, Y, and Z questions?" When you cite to this code in a letter to the insurance companies, I guarantee you they will perk up and have a better response than if you don't, because they are afraid of this. Also, if you point out in that letter that they're responsible to know this without you having to tell them, and then you tell them, they're really going to pay attention. Continuing through, in New Jersey, they must begin an investigation within 10 days of receipt of a claim. Now, this one's critical. I hear complaints all the time about adjusters who are delaying inspections, who aren't moving the claim along fast enough for the carrier. They've only got 10 days to start that investigation. That's it. So from the date you send your notice, 10 days later, they have to start that investigation. And as you're going to see later, that actually means they have to get out to the property within those 10 days. Now, when less clear justification exists, claims must be, it should have been must, sorry for my rush, be determined within 30 days from receipt of a properly executed proof of loss. A lot of what we're going to be talking about today is going to be focusing on time limits. Truthfully, one of the biggest complaints that I ever get, both from clients and public adjusters, is that the claims aren't moving fast enough. Now, I'm a lot more restricted as an attorney in my timeline because I'm stuck with whatever the court tells me to do. And those timelines are never 30 days. I look at timelines closer to 6 months to a year, sometimes even longer. So you can use this to your advantage and use a proof of loss to force the timeline. Now, if it can't be done, i.e. a claim resolution can't be done in that time, they must send written notice within those 30 days stating the reason why additional time is needed. Now, the why is really important here, because just saying that the claim is ongoing, or the investigation is ongoing, or the investigation is continuing, isn't the reason why. You need to know, why is the investigation ongoing? That's a big difference, right? Because you get that form letter that says investigation is ongoing, and they think that that complies. It doesn't. It doesn't meet the standard as to understanding why this is actually being delayed. And then you need to update every 45 days in writing, stating forth why the additional time is needed. Again, just saying the claim is ongoing is not enough. They need to give you an actual reason. What do they need to continue to finish evaluating the claim? Are there inspections that are necessary? Documents that are being requested? What could it possibly be? Here's another great one that comes up in the same code. All amounts agreed to must be paid within 10 days of that agreement. You're going to see this a little bit later, but that means as soon as you have an undisputed amount, they've got 10 days to make payment to you. That's 10 working days, by the way, not just 10 calendar days. Moving on to the next one. As you notice, by the way, these code numbers are changing. So if you're going to be looking these up or trying to do some of your own research, just note the code number that's on the top. You can find the actual language that way. So under 17.8, denials must include a cite to the specific reference to such language and a statement of facts which apply to the policy. What does that mean? They have to give you the specific policy language, and they have to tell you the facts that make that policy language apply. Well, why is it? It's so important that it says specific reference, because what carriers tend to do, as all of you know, is they cite 3 or 4 pages worth of copy and pasted policy language as to a reason for a denial. And they'll probably put in every section under the sun when the only thing that they're actually applying might be something like wear and tear. You have a right under this provision to write to them and say, I don't understand what this means. Remember, we saw that one earlier. It has to be clear and understandable. I don't understand which provision you're actually citing to and why it applies. So I need you to be more specific. I've actually had bad faith claims that have been successful because carriers have refused to do that. Carriers have refused to give specific policy language and just cited everything, and we're left with, I don't know which one you're actually relying upon here, because you're citing things that clearly don't matter. All of this must be in writing. So doing it over the phone, giving you a verbal denial over the phone is never going to be enough. Carriers are generally okay doing that. All denials or compromises must include a reference to the complaint, to the claimant's right to sue. Now this one's really, really important, because constantly I will see denial letters in New Jersey that don't have this language. And that's critical to my evaluation as to when the claim can be filed. Because if they violate this, the courts have come back and said, hold on a second. You have violated the regulations as to the requirement to notify your insured of the suit limitation. You didn't do that when you denied this claim, so you can't use that against them. You can't use the time limit within the policy. So if they deny a claim, or if they do a compromise settlement with you, they have to include this language. Otherwise, the courts have come back and said you cannot rely on that language. It makes a really big difference. So take a look at your denial letters that you might want to send to litigation and see if that language is in there. Continuing in this, they can't require a time limit if a release is requested. Now we're going to see a little later some of the rules that both fit for Pennsylvania and New Jersey. They're in a different slide, and we're going to talk about releases. But in the rare situation, and I cannot stress how rare it is that a release is appropriate in the adjustment of a claim, rare like 1% of the time rare, if it is done, they can't put a time limit on it. They can't say, hey, you need to sign this release within the next 10 days or we're going to close our file and not pay you, right? That's not appropriate. They absolutely must pay the undisputed amounts. This one comes up a lot too. You're negotiating a claim. You guys have all agreed to, 50% of the loss, no questions, it's owed. And there's still a dispute as to the rest. In New Jersey, they cannot withhold the payment of the undisputed amount just because other portions of the claim are still being adjusted. Law says they're not allowed to do that. They can't force litigation by underpaying a claim. Now this was actually really great for me too, but if you can keep a good enough record as well, if we can show a pattern that they are constantly forcing people to file litigation, and that we are constantly showing success in those litigations, we're going to have a lot of leverage because of this provision. They must have facts to support the denial. Now this one's actually important because this comes up all the time when there has been no inspection of the property. The carrier has a responsibility to inspect, the carrier has a responsibility to build facts to support the denial. If they don't have that and they're just basing it off of 1 or 2 things that don't actually fit based off of what you've seen, and you've notified them of that, they are not going to be in a position to provide a proper denial. Another great one here is that payments must include estimates. That's great because when they actually make a payment on a claim to an insured, if they haven't provided a subsequent estimate with it, it's an invalid payment for the claim, and there's more to fight on that end as well. Again, doesn't come up all the time because carriers generally do it, but it's important to know that it's required. This one is another fantastic one for insureds, which includes any of your clients, hopefully, that they are actually insured. If there is a reason the carrier is not paying a claim, they must give the insured a general description of what would be needed to establish coverage. What does that mean? Well, it means that if you ask the carrier on behalf of the insured, hey, what would I need to give you to show that this was a covered loss? They have to answer you. I want that to sink in for a minute. So you have a claim, let's just talk about a roof claim, right? Wind damage to a roof. They come out, they send an engineer, engineer says, no wind damage, wear, tear, deterioration, yada, yada. You send a letter to the carrier, and you cite this provision and say, hey carrier, I recognize you had an engineer. What would I need to show you to prove, in essence, that this is a covered loss under the policy? They are required to give you that general description of what the loss, or what it would take to make this a covered loss. That puts a ton of power in your hands. That if you do this, that you've got an opportunity to force them to say, here, give me this and it'll be covered. Well, now you've got a roadmap to coverage. That's huge. Really let that one sink in. Moving on to the next code, notice the number change again up here, 1710. Information and calculations for depreciation must be kept in their claim file and must be fair. Actually says fair and equitable. Now this one's unique because it says that it has to be kept in the claim file, but doesn't necessarily mean it has to be provided to you. But this comes up often for me when I have to file litigation on these, because after the fact, I've had a lot of claims where we fight just over depreciation percentages, that it's unreasonable, that under this provision that it's not fair to depreciate something by 80%. There's a question that I think comes up later. I'm going to address it now just because it fits for the timing. The depreciation must be based on calculations and must be fair. One of the questions that came up is depreciating labor. Short answer from our position and everything I've ever litigated is you cannot depreciate labor. Depreciation of labor, there's nothing to depreciate. Depreciation accounts for items that wear over time, be used, and lose some of their value. Well, the cost of a person to paint a wall does not lose value over time. The paint on the wall does, and you can depreciate that material, but the actual labor doesn't. Where this comes into a little bit of a tricky place is in Xactimate and some other software programs. They don't differentiate between labor costs and the line item for the material costs. So they'll put something like R&R drywall, and they'll depreciate it. Well, that R&R drywall consists of the cost of the drywall, the cost of the nails that go into the drywall, and those things depreciate. It also accounts for the cost to take out that drywall and the labor to put it back up. Those things don't depreciate. Well, if it's all in the same line item, it becomes nearly impossible to differentiate, and thus you've got this problem. It's one of the reasons that I've started to push adjusters away from software programs like Xactimate. I'm seeing much more success from adjusters that either use their own internal software systems, use estimates from contractors, or some other type of lump sum contract that simply says, here's the cost to do the job, and you can even line item it based off of the project, but not differentiate it so line by line as something like Xactimate. So, long story short though, is if the carrier down the road cannot calculate this, cannot give me an explanation as to, hey, why did you do 40% on this thing versus 70% on this one, they're going to be in violation of this. And unless the question has been specifically negotiated, the carrier remains liable for hidden damage related to the loss. I just got this call yesterday actually from an adjuster who said a client had called them saying the contractor found more water damage behind the shower from a leak that had occurred. Now there's a question of whether or not that water damage is related to this loss or just something else that was happening with the shower. But the question became, well, look, we've already negotiated the loss. It already went to appraisal, and we already had an amount. Or can she go back? And the answer is yes. They can always go back for more on hidden damages. If the carrier didn't know about it, it couldn't possibly have been part of the negotiation previously. It's new damage in the sense of negotiations, but it's related to the old loss. Go back. No question about it. In New Jersey, and really almost everywhere, the insurance company can't require the insured use a specific contractor. So if they ever come out and say, "Oh no, you've got to use X, Y, and Z person," they're not allowed to do that. Here's another really great one. This one is worth taking note of. If the carrier wants to inspect, it must be done within 10 working days from the claim notification, unless the client refuses to allow the inspection in that time. This goes back to what we talked about previously. Investigations have to start within 10 days. Well, they actually separate out the requirement that the insurance company get to the property within 10 days. Period. They have to be there. And the whole reason is that the insurance commission and the insurance departments of every state, they do not want these claims to be delayed. They want them to be done quickly. One of their biggest frustrations are claim delays, and those are one of the number one things that get complaints to the commissioner. So if you've got a situation like that, you can point to these regulations and say, hold on, you haven't done this, I've put you on notice of it, now you can file your complaint to the commissioner and put them in a little bit of hot water. I apologize, I do feel like I'm going quickly through these, but I know how many slides there are, and I generally don't like to be too much over an hour. If you guys have questions, I just want to remind you, you can put the questions into the chat. I see Mario typing away every once in a while back there, so I think questions are being asked. But anything you want to know, if you need to slow down on something or go back to it, let them know. We can always adjust it as needed. All right, this one of the big ones. Noteworthy, everybody make sure you're paying attention right now. In New Jersey, the carrier must give you their estimate before you begin negotiating a loss. I would bet a lot of money that the majority of people on this right now, and even the majority of people who watch this later down the road, didn't know this. Because they're probably going to be in a position where they ask for your estimate first, maybe they even ask for your ESX file or some other version of it. But ultimately, it is on the carrier to provide you their estimate before negotiations begin. Use that to your advantage. You never want to be the first to put a number down on a claim. It really doesn't work out that well most of the time. There's, of course, other scenarios where you want to set reserves and things like that, but really the idea being let them put the first number on it because they then start the negotiation game that way. Now, if the carrier, another really great one for New Jersey, and this one is somewhat unique to New Jersey, I haven't seen it in many others. If the carrier has an estimate lower than your contractor, they need to supply a contractor who would make the repairs in accordance with generally accepted standards for safe and proper repair. This is a really big deal because if the carrier is writing their own estimate, you can, and I've used this personally, for clients of mine that I've gotten involved pre-litigation, and I send a letter saying, hold on carrier, we can't find anybody to do it for the cost you're saying, you've got to give it to me. And during this time, the carrier's been extending the ALE for the client because, you know what, the carrier can't find somebody to do it for that price either. So it puts them in a really tough space to actually stand by their numbers. Ultimately, they couldn't, so they paid more. What's even nicer about this, it also says that they have to do it to generally accepted standards for safe and proper repairs. Now, that means they have to do things up to code. Code is the question for accepted standards for safe and proper repairs. That's what the code is. So if they're trying to get someone in there who won't be doing it up to code, violation of this. That's big, guys. You need to make sure you're not understanding this because you can use this to your advantage. All right. So those are the big ones from New Jersey that are somewhat unique to New Jersey across the board. Here's a list, and this one's a little bit smaller. There were some complaints last time that the text was pretty small to read. And I tried to make it generally bigger so that everyone could read, and I tried to contrast the colors a little bit more to make it easier to read. But just like last time, if you need copies of these slides, make a request in there, or even better yet, shoot me an email at adiulio@wdblegal.com. I'll be happy to send you the slides, no problem. These are regulations that are similar in both New Jersey and Pennsylvania. And I'm going to venture a guess you're going to find it similar in most other states. The states I've practiced in, it certainly has been the case. So, they must disclose all pertinent benefits, coverages, and provisions of the policy. Well, no kidding, of course, but what does that mean? It means they must give you the policy. This comes up constantly. I need a copy of the policy. Can you send it over? Sure, no problem. And you send them the deck page. Okay, that doesn't actually tell me all of my benefits, coverages, and provisions. So the policy, can you send me the whole thing? You can cite to these regulations in your letter requesting the policy, and it gives your letter a lot more strength. They can't conceal those benefits. Again, that only goes in really conjunction with this. They can't try and hide that policy from you. They can't make proof of loss timing deadlines unless it's in the policy. This is another good one because often I will find carriers who are trying to ask for a proof of loss or have denied a claim saying a proof of loss wasn't provided in X amount of time, even though the policy didn't actually have that. For example, if the policy says you have to provide it within 60 days upon a request, that doesn't mean it has to be done within 60 days of the claim notification. So the carrier can't deny that claim because you didn't provide the proof. They also couldn't shorten it. They couldn't give you a proof and say, oh, you know what, I want that in 30 days this time. Another one, they can't request a release that extends beyond the subject matter that gave rise to the claim payment. Now, we talked briefly about releases, and I told you about 1% of the time they can ask for a release. And it's unbelievably limited. If they want to give you a release, I want to give you an example. Let's say this TV was damaged in a loss, and they want to pay for this TV. They could send me a release that says, for payment of this TV, we're going to give you $250, and you're willing to release us of any future payments just when it relates to this one television, and only in relation to the contract itself. That's it. They can't say we're releasing all future claims for anything like bad faith, unfair trade practices. They can't do that. They can't say that we're releasing you of all other claims under the policy. They can't. In essence, the releases are really useless in the eyes of the legal world. To fall under this and make a proper release under it, it's going to have almost no legal value whatsoever. Because all it's going to say is, hey, I'm not going to sue you over $500 for the TV because you paid me $500 for the TV. That's about the extent that they've been doing. Here's another really, really big one. Both Pennsylvania and New Jersey, and again, most other states as well. There's no partial checks that use language that could release the carrier from future payments. I.e., when they put that line on there that says full and final payment, not allowed to do it. The carriers are not permitted to add in language on the memo line that suggests in any way that this is it. I just had a client who was paid on a loss policy limit, but was not paid for the debris removal or any of the extra expenses, extra additional coverages they had. And when they was sent that check, it had that line. I sent a letter immediately to the carrier saying, hey, I need to confirm you're not standing by this because you're not allowed to under this. You're actually in violation of the statutes and want to confirm it. They wrote back, ultimately, of course, he could cash the check and they would apply it. 10 working days to acknowledge the claim was put in. So if you put a claim in and you get radio silence after day 10, they're now in violation of this. They must provide necessary claims forms, instructions, and reasonable assistance in pursuing a claim and complying with the policy. Now, what does that mean? That means that the carriers, if they're asking for something, estimates for items, let's say, well, they're going to need to give you a form that says, well, here's how we would like it laid out, if you ask. They don't have to only use that form. Just like with proofs of loss, there is no such thing as the standard proof of loss. It doesn't exist. There's no such thing as the carrier proof of loss because, again, there's nothing that says a proof of loss has to be a specific way. But if you ask for something and they don't give it to you, they could be in violation of this. Another really powerful one that hopefully everyone knows because they should be using it, an appropriate reply within 10 days to all pertinent communications that suggest a response is expected. That means they get 10 business days to respond to your letter with a substantive response. Not just, we got your letter, we're reviewing it. That is not good enough. They need to have an actual response within 10 business days. Can't deny payments because someone else is responsible unless the policy says otherwise. Well, this one can come up a lot with things like condo claims. Condos, as anyone knows that does them, they're annoying claims, but there's often two policies that could apply. Unless the policy specifically states one reason or another as to which policy is the master policy, or the one that should make first payment, they're going to be required to make that payment regardless if someone else is responsible. This is also true for claims of third-party damage, right? So just because someone else might have started the fire and could be responsible doesn't mean they can't pay or shouldn't pay the insured. They actually have to pay under this provision. This is another great one. If the claim is still being negotiated, the carrier must send notice 60 days before the suit limitation period expires that there is a limitation on the time to sue. In Pennsylvania, that's 30 days. So what does this mean? So a lot of policies, as you're aware, have a 1-year suit limitation. And in New Jersey, 60 days before that suit limitation would run up, they have to give you notice of it. That's not terribly common in New Jersey, because in New Jersey the statute tolls while it's being adjusted. So it's rare that this is going to come up. But it's still in the code. In Pennsylvania, however, at least 30 days before the time period is up, the carrier must, if they're still negotiating a claim, tell you your suit limitation is coming up. That's a really big deal, because if they failed to do that, you're now going to have an excuse to say, hold on a second, you didn't notify us. If I happen to file suit and it's after the 1 year, there's a good chance they're going to be kept on the hook for that. All right, a few more. Oop, what happened there? Let's try this again. All right, there we go. This one's another really important one, because some adjusters for insurance companies can get kind of aggressive. Truthfully, some public adjusters can get aggressive too. And things like litigation can come up. And you can say, oh, I'm just going to sue you for this. And if the insurance company ever makes a representation of, go ahead, sue us, we'll just appeal it, they're in violation. Because what they've come down to say is you can't just tell an insured, hey, don't bother suing us because we're just going to drag this thing out forever. And as a result, it's going to waste a lot of time and money. Just take the money we're offering and run. They're in violation of this code. Delaying a claim by requiring a preliminary report and then requiring a proof of loss with substantially the same information. This one happens all the time when they try to deny claims for failure to provide a proof of loss. What's really nice is if you've given them all of the information that would otherwise be contained in the proof of loss, the law steps in and says, hold on, carrier. You don't get out on some technicality like they didn't send in proof of loss simply because you didn't get that letter. You've already had all that information. You knew what the claim amount was because you got the estimate. You were presented the loss from the insured, so you knew what they were claiming, what the cause of loss was. Here it is in the letter. All of that stuff is information that could be contained in other documents, and that's not enough to get out of this. I want to make one important caveat, especially considering what just happened. This rule does not, actually all of these, don't apply to FEMA and flood claims. So proof of loss in a flood claim is 100% critical. It is an absolute bar to recovery if you do not provide the proof of loss in flood losses, so make sure you do it. FEMA rules are far more strict, far more regulated. Make sure you comply with them if you're dealing with any of this stuff from the recent hurricane. This goes back to something we talked about earlier about sending partial checks and withholding checks. They cannot fail to pay a covered part of the loss just because other parts are being negotiated. That's really big, guys, because all you need to do is start getting agreements on little portions of the claim, and they're going to owe those payments to you. As soon as the agreement is made, they've got 10 business days to cut that check. So make sure that you do that. This is one of my favorite ones that I had learned in reviewing all of these forever ago. No insurer shall deny a claim for failure to exhibit the property without proof of demand and unfounded refusal by a claimant to do so. I'm going to read that again because it's that important, and this is actually language from the statute itself. No insurer shall deny a claim for failure to exhibit the property without proof of demand and unfounded refusal by a claimant to do so. That means if the carrier did not specifically ask you to see the property, and the insured specifically said, no, you cannot, they cannot deny a claim simply because there was a failure to exhibit the damaged property. I hope you're paying attention because that one is very, very big for this industry. Those ones were all the ones that kind of split between Pennsylvania and New Jersey. I want to go through a few more from Pennsylvania because there's a few nuances that are important. And the goal of this, I hope you're understanding, is that these laws contain information that you can absolutely use to assist your claims. And it contains statutory language that if you put it into letters and keep a calendar, it will help you move these claims much, much faster. So this is the Pennsylvania Unfair Claims Settlement Practices. They must complete their investigation within 30 days. This is similar to what it says in New Jersey, updates every 45 days. But here's the kicker in PA. And they must state when a decision on the claim may be expected. Now, I have reviewed hundreds of these delay letters from insurance companies, and I truthfully can't think of one that says when a decision on the claim may be expected. So you should be contacting the insurance when you get this 30-day, we haven't made our decision yet, or 45-day follow-up. You need to be asking the question, okay, first, did you give me a reasonable explanation? Most likely not. But when can I expect this to be resolved? They've got to give that to you under the state law. In Pennsylvania, they've got 15 days from proof of loss to provide a coverage decision. 15 days, that's it. And if they don't fit that 15 days, they've got to give you the updates as to why. And they've not only got to explain, again, a reasonable basis for why they can't do it, but they have to give you the timeline of when they will expect to have that answer. So, note, by the way, a slight change up here. So it goes from unfair claim settlement practices, which is a different one act in Pennsylvania, to the Unfair Insurance Practices Act. These are two different statutes in Pennsylvania. Both have a lot of important information. This one was one I actually found recently. And it's incredibly important. And it talks about the definition of what a renewal is. And normally you would think, okay, who the heck cares, right? But it has this added line down here. I've got a case, a few cases actually going on against certain carriers who've added provisions into their renewals that reduce coverage. If you know me, you probably know who I'm talking about. But what I derived in my research was this provision, part of the Pennsylvania Unfair Insurance Practices Act, that says a renewal policy is to provide the types and limits of coverages at least equal to those contained in the policy being superseded. This means you cannot reduce coverage in a policy at a renewal. That's really big. I feel like I've been saying that a lot on these, but I feel like adjusters don't actually know some of this stuff. Candidly, like I said, I didn't even know this for a while. But if you have an insured that's been with a certain insurance company for X number of years, let's say 10, 15, 20 years, you can go back and find out, well, what has changed recently in those policies, and was it a reduction of coverage? Because if all they were doing was renewing, they're not allowed to do that. They cannot add in a new endorsement that reduces coverage. Make sure you look into that because you can find yourselves in a position to have a lot more coverage. Also note, by the way, Pennsylvania doesn't have the same provision about applying to not applying to commercial policies over $10,000 in premium. So this goes all the way up. Your commercial clients as well. If they've had a reduction in coverage in a renewal, they're going to be in violation of this. Under Pennsylvania law, they can't make, publish, or issue any estimate or statements that is misleading as to the reserves on a file. Now, I don't know how often or how good your relationships are with the adjusters on the inside, the carriers. But if you ever get into a talk about reserves, they cannot provide you something to mislead or suggest that the reserves are lower than what they actually are. Again, I'm not sure how often that actually happens in the field, but I wanted to throw it in here just in case it does come up. Another one that comes up, and I'm not going to spend a ton of time on this because I want to get to the questions, because there have been a lot, but the reasons for cancellation and non-renewal are also contained within the Unfair Insurance Practices Act. And generally, you've got material misrepresentation in the application, fraud, pretty much at any time fraud is going to bar you, omissions or concealments of material facts during the application process, substantial change or increase in the hazard or the risk since inception, substantial change as a result of negligence or willfulness on the insured's, failure to pay a premium, or any other reason approved by the commissioner. Now, first and foremost, as far as I'm aware, there are no other reasons approved by the commissioner, so you don't have to worry about that one. Easy ones are failure to pay, fraud, really no question there. Material misrepresentations and the substantial change or increase in hazard are the gray areas of this. Now, material misrepresentation means it has to be something in the application that would have changed the way they wrote the policy premiums or not written the policy at all. Some things are material, some things aren't. Usually that's going to be a legal fight, though, because the carrier is almost always going to say everything is material, but that's simply just not the case. This is the one that comes up all the time after a loss. Because insureds, I'm sure, ask you, well, can my insurance company drop me because I made a claim? The answer is no, they can't drop you because you made a claim, but in their investigation of your house, they might determine that there's been an increase or substantial change in the risk to them, and that's why they're going to drop you. It's an unfortunate reality and a workaround to what I think the insurance department meant, but nevertheless, it is in there. So something important for you to know. More importantly, though, is how they cancel. That's also regulated as part of this, and there's a very specific outline. Forms need to be approved. They need to be 30 days before the cancellation. It needs to give you specific reasons. This is where the insurance companies screw up the most. They also have to provide a notice to request a review within 10 days. So they have to tell you, hey, if you want this reviewed, you've got to tell us within 10 days and the commissioner will take a review. It has to tell you you can get other insurance in other places. Has to be understandable language and notice of the appeal process. The only one I want to talk about real briefly here is the specific reasons. I have had claims, or I should say refusals to renew or cancellations overturned by the commissioner because the insurance company has only said there's been an increased risk to the insured. And that increased risk that we saw in the previous one, right, substantial change or increase in hazard, just saying that alone isn't enough. We need to explain why. And just putting that simple language doesn't do the trick, so you should be checking that for your insureds. Just give them an added benefit to your services. This is another important one. If you're ever involved with litigation with another attorney other than myself, since I'm already aware of this, you should let them know that if they request all complaints, the insurance companies are required to keep 4 years of records of every single complaint that they get about themselves, the policies, or otherwise. So they've got to keep those records. The attorneys should be requesting those. Okay, whew, that was a lot. I actually feel like my legs are a little tired. Not that I'm standing any longer, but it just feels more. What do you do with all this information? All right, this is a lot. You should absolutely be going back to your specific state and reviewing your acts and regulations and codes to see what your insurance companies are required to do. And with that information, the first thing you should do is have a claims calendar. I have seen public adjusters be so much more successful with moving a claim when they have a claims calendar that outlines a timeline of your loss. So, step one, report the claim. Within 10 days, these things have to happen. An inspection has to be made of the property. You have to receive written notice that the insurance company has received the claim. Then by day 15 in Pennsylvania, or whatever the case may be for your specific state, I need a decision from the insurance company as to what the claims coverage position is, or an explanation as to why it's going to be taking longer, right? Create that calendar as to these are the steps, and almost every claim you have should be able to be resolved within 2 months. If you really keep the pressure on them, there's really no reason it should go past that. Now, it's going to happen, don't get me wrong, but when that happens, when it goes past those 60 days, you're going to have ammunition now to say, hold on, insurance company, you have not complied with the regulations X, Y, and Z by taking too long, by not reasonably investigating, yada, yada. We need to get this thing moving. Making documentation is important. So you can put the carriers on notice of these violations. Once you have an understanding of all of these, and by the way, I didn't go through all of them. There's even more in there. And they're basic ones, right? Like, they do have a responsibility to investigate a loss. They've got to make reasonable determinations as to coverage. But put them on notice in writing. This is the stuff that proves bad faith claims, guys. This is what makes the difference. You have to prove they had knowledge of their violations, knowledge of their losses, or their errors, so you want to put that stuff in writing. And then you can use these violations to get what you actually need to resolve the claim. I told you there was an early on that we looked at where it says that they've got to provide you with a general description of what information would be needed to provide coverage. So use that, right? You've got a claim. You write a letter that says, hey, under this provision in the New Jersey Code, you've got to provide a reasonable or a general description as to what would be necessary for coverage. Give it to me, right? Use that to get what you need. All right. Time for the questions. This one I feel like I am flying through, guys. If you've got more questions, add them in. I've seen Mario type a few at least, so keep them coming. The first one is, how do things change if the policy is a surplus lines policy? Well, this is a great question, and probably my favorite one of all of the ones that was asked. In almost every introductory section of these provisions, it still will apply to surplus lines carriers. There are different regulations and some things that do not apply to surplus lines carriers, specifically when it comes to minimum requirements for what's in a policy. And that's what everyone thinks about. Everyone thinks, oh, well, surplus lines, they're not part of the same purview as the regular carriers. But that's not true for these regulations. They are still considered a person or an insurer under these provisions, and it would still apply to them. So absolutely, you can hold companies like Lloyd's responsible. In fact, the NAIC model code and a number of these codes that have adopted it have actually noted Lloyd's as one of the types of insurers that is still covered under these provisions. If you've got a specific carrier that for some reason is telling you they don't fit the definition, you can go to the preambles or the definitions sections of these codes and look up what the definition is for an insurer and show that to them and say, yes, you are. Surplus lines carriers are absolutely included, as are the subscriber policies, the Lloyd's of the world, Tokyo Marines, things like that. All of those are included. I appreciate very clearly people are adding more questions in, and I thank you for that as well. What has precedent, state administrative code or policy contract? Second favorite question of all the ones that were asked, and the answer is the code. The law is always going to supersede. So you cannot contract around these provisions that are required based off of the adjustment of these claims under the Unfair Claims Settlement Act and other areas. Because most of the time the codes will say, when it comes to the proofs of loss, they can't put a time limit unless the policy says otherwise. There are a lot of provisions like that allow for an out for the carrier, but not for things like the timing on responding, right? They're not putting in the policy, hey, we're going to respond within 30 days to any pertinent written communication when the state law says they can't do it in more than 10. They're not going to be allowed to do that. So the code will be the superior document here. All right. I'm in Indiana and understand that Indiana has no statutes of these kinds. Is that correct? First, I've always got to put the caveat. I am not licensed in Indiana. I cannot practice law in Indiana, and I can't really give legal advice in Indiana. However, with that being said, I'll provide you this. You might want to look these up. So these are codes in Indiana that reference the Unfair Claims Settlement Practices Acts for those areas. You can interpret those. If you've got specific questions on them, give me a call. I do have at my office, one of my attorneys is licensed in Indiana, and we're happy to help you with those claims. All right. NARS just doesn't respond. Handle Berkshire losses. Literally spend months on easy claims because they don't respond, don't answer the phone. It's every claim. There was no question here, but I understand the sentiment. And what I want to represent is that you can use these codes to fight this problem, right? You have in your willpower now, in your arsenal, codes from your locals, from your state agencies that outline exactly how long they have to respond to pertinent communication. So on day 11, when they don't respond, you write back and say, you're now in violation of X, Y, and Z code. We're requesting, again, a response to this letter. And if they still don't respond to that, your very next step is to report them to the insurance department. Because that's what the insurance department is there for. The insurance department does not care about whether the insurance company thinks it's wear and tear to a roof or hail damage. They are never going to change the outcome of that investigation. If they've got an expert, an engineer that says, nope, it's not hail damage, and you do, the insurance department doesn't care. But insurance department will care if they are not responding to communications and violating these regulations. That's what you want to be making complaints for. So use this and recognize that you now have multiple codes to put in those letters to fight back. If an insurance company drags out a claim almost a year, neighbor's tree on house, can insurance company be barred from subrogation? This one's unique. Most likely not, right? The limit on the subrogation claim is going to be really based off of prejudice and whether or not the carrier for the neighbor is prejudiced into in any way by the fact that it has been delayed. However, the reason I kept this question so early on in the list is because this has nothing to do with the coverage on your loss. As we saw in the earlier ones, an insurance company cannot delay or deny your claim simply because someone else is responsible. So make sure that you're noting that and sending them a letter that says, hey, I appreciate maybe you're waiting on subrogation or there's some other issue, but that gives you zero right to not pay my client, your insured, on the loss because just someone else is slowing this down or someone else isn't going to be responsible anymore or anything really about subrogation. Has no bearing whatsoever on the coverage for your loss. All right, any specific laws in North Carolina that would assist insureds on unfair handling or delays? All right, same caveat. I am not licensed in North Carolina yet. I'm actually in the process of doing it. I do have attorneys down in North Carolina that work with my office for filing claims, so I'm happy to help you if you've got claims down there and need assistance. With all that being said, you should probably check these two codes out, right? We've got Article 63 and Chapter 58 of the General Statutes for Insurance. Both relate to a lot of the same things. You're going to recognize, as we talked about earlier, the NAIC sent this code out to all 50 states for their model code. And as far as I'm aware, I don't believe there's any state that has failed to adopt at least some version of the Unfair Claims Settlement Practices Act. So you're going to want to find it. It's just sometimes it can just be difficult to locate. If you can't find it for some reason with a Google search, let me know. You're going to want to look up the general terms are unfair trade practices, unfair claims settlement practices, or unfair insurance settlement practices. Those are generally what you're going to want to be looking up, and something will trigger within the first few results on Google. All right, a little bit longer on this one, I apologize. How can a carrier justify applying depreciation to items within an estimate where only labor is involved? Great, this was the one I already addressed. I'm not going to worry about reading the rest of this. You've gotten my response from earlier. If you're jumping onto this Lunch and Learn later and this was your question, well, unfortunately you're going to have to go back. I don't want to waste everyone else's time. But remember, the short answer is you can't depreciate labor. Is there a line where a carrier's employee and its vendors cross where they themselves become liable along with the carrier for wrongdoing? We recently had a case where, in addition to the unfair claims practices allegation being made, so too was violations against the protections afforded to the elderly, which opened up a completely different book of law, one of which included attorney's fees. So, short answer to this question is yes. If the vendors or the actual employees are going outside the bounds of their representation and doing things so egregious that the carrier is going to take the position that they weren't authorized to do it, they could be held liable. We have actually had to start filing claims against insurance appraisers. So the appraisers named by the insurance company, we've had to start filing suit against them because they refuse to appraise losses or fail to appraise them appropriately. Things like not writing estimates on a loss and forcing it go to an umpire, they're not allowed to do that. So if the appraisers or the vendors are doing things that are really that egregious, there could be personal liability against them. It gets kind of messy when it comes to the actual employees of the carrier versus a vendor, but it's certainly something that can be explored depending on how bad the conduct is. What's your idea or format to place a carrier on notice for unfair claims practices violations? Writing is key, right? So no matter what you do, you're going to want to do it in writing. I actually prefer email over snail mail. And while snail mail looks more formal, and I recognize that, in a perfect world, you would just PDF a letter that you've written out. So now you've got the nice formal looking letter, but you've emailed it. to the carrier, and what you're going to outline is that, based off of your training and experience, here are the unfair trade practices laws. You're not practicing law, but it appears that they are in violation of these and that you're looking for them to correct that information. You always want to make sure it's clear that you're not practicing law. You're not lawyers. You're not allowed to do that, just as much as a contractor is not allowed to adjust claims in most states. So you want to put them on notice of what the law, of what the code is, indicate you're not practicing law, but you believe that they're in violation based off of X, Y, and Z reasons, and ask them to correct it. So let's use an example. They aren't responding to your correspondence. One of the biggest problems out there. You send them a letter that says, please accept this letter as follow-up to my letter of X date. In my review, you have not responded to that letter within the past 10 days. Pennsylvania Code XYZ, I don't have them memorized unfortunately, indicates that you have to respond within 10 business days to pertinent communications, but you have failed to do so. Please respond to this letter to avoid reporting this issue to the insurance department. Period. Now, something among those lines is going to do the trick. But whatever you do, you want to put it in writing. The reason I like email more, by the way, it's easier to track. So you've got much better records that you actually sent something versus if you send snail mail, it really is just a he said, she said. Yeah, here's the letter I sent. Well, how do I know you put it in the mailbox, right? If you've got an email, it actually has the sent information and all that good information on there. What's your definition for the carrier to provide their calculation of depreciation, as well as what is considered a fair amount of depreciation? This is a great question. So, and this is why it was important what this one said. It said that the carrier has to have the calculations in their record. It doesn't actually say they have to provide the basis for it to you. But it will be important for the claims where you believe the depreciation is incorrect that you put them on notice of this so that if you have to sue, we've now got evidence that they were supposed to keep this in their records and they did or didn't do that. As for what is a fair amount of depreciation, I generally live by the stance that age of an item has zero bearing whatsoever on depreciation, and that what actually matters is the condition of that item. I think you see in a lot of homes that room that nobody uses, right? Whether it be a formal living room or something like that, where that carpet could be 20 years old, but it's maybe been walked on 40 times in its entire life. That carpet is going to look way different than the 20-year-old carpet in the playroom up in the kids' bedroom, right? It's just going to be different. So the age isn't really a factor. What you're going to care about is the condition of the property. What I do when I have my clients formulate contents invoice estimates, I tell them to put a rating of 1 to 100 on it for its condition. 0 being, 1 being trash, 100 being, brand new in the box, and put it on that scale somewhere of where it stands. You're not going to find a lot of items in an actual person's house under 50%. I mean, 50% depreciation is a lot. Generally, the most I see, or would ever consider not fighting over, would be about 40%. Anything over 50 is a red flag for me, because the truth is most items in a lot of people's homes aren't that bad. They're not so far. They're past 50% of the life expectancy or their value. All right. Thank you guys so much. This is a recap for my information. If you guys have questions, anything further on this, I was close to my hour. You can feel free to call me. My cell phone is right here, email address, and our website if you need anything additional. All of these videos are always available after the fact if you need to go back or have other friends or colleagues in the industry to watch them. And again, I really want you guys to throw in your thoughts. If you guys have recommendations on what would make this better, let me know. If you guys have recommendations on topics, I would love to know that. And as to the one, smart, we'll call it Alec, smart Alec, not the other A word I want to use, about the free lunches, you know who you are. I would love to do these in person, but given the restrictions and distances, it meant free lunch and learn. It wasn't just free lunch. So maybe one of these days we'll figure out a way to do a lunch for all you guys. All right? Thank you so much. Always happy to do these. Take care, guys.